We certainly talk a lot on this show about what's at stake this November. It sounds like hyperbole when I often say that American democracy is on the line, but I'm not making it up. It only takes a couple of well-placed wins among the dozens of Trump loyalist election deniers who are running for key offices this fall to bring the system of free and fair elections down. But even if every conspiracy peddling big liar on every ballot in the country is defeated, the threat to democracy doesn't end after Election Day. And the damage of Donald Trump's presidency, which cannot even be fully imagined yet, is perhaps nowhere more potent and enduring than on the Supreme Court, which begins a new term on Monday. The court, which now includes Justice Ketanji Brown Jackson, the first black woman to serve on the Supreme Court since it first assembled 232 years ago. But it also includes 3 Trump-appointed justices who now form the heart of an ultra-conservative majority that has proven itself willing to roll back some long-protected personal rights, that untold cost to American society. And that court, starting tomorrow, is set to hear a slate of cases that could prove as consequential and damaging to democracy and individual freedom as the overturning of Roe v. Wade has been. Here to discuss the upcoming cases on the docket and the absolute best legal minds out there, Jeffrey Rosen is the president and CEO of the National Constitution Center. He's a professor at the George Washington University Law School. Fatima Goss-Graves is the president and CEO of the National Women's Law Center. Welcome to both of you. Thank you for being with us this morning. I want to try and get through a few of the cases that are coming up and get your thoughts on them. Fatima, let's start with you. There are 2 cases that have a lot of people worried this year about voting rights and the future of democracy. Let's start with the one coming out of North Carolina. It's called Moore v. Harper. And in this case, North Carolina's Republican-controlled legislature is claiming that its own state Supreme Court cannot overturn its gerrymandered congressional maps. Tell us why this is such a big, important case and what's at stake.
So the issue that the court took up is whether there really is any sort of remedy at all to the sort of extreme partisan gerrymandering that you have seen coming, not just out of North Carolina, out of state legislatures across the country. It's a tactic to limit the voting power of people in this country. And they've offered this new and wacky theory that would mean that voters across the country would have no judicial remedy in state court or really in federal court, because the Supreme Court has already addressed that, to fight partisan gerrymandering. And so what that would do is throw elections into chaos. There would be hundreds of laws that would be nullified if this theory were accepted. And it would also potentially reach foundational state policies for processes like voter registration, mail voting, many of the things that have made voting more accessible. And so the question is, when you have these extreme state lawmakers, is there any check on the steps that they are taking? And the legal chaos that you talked about in your opening with Dobbs, we know what it is like to unleash that sort of instability. The country is still grappling. Imagine that same level applying to voting.
So, Jeff, let's talk about this and another redistricting case out of Alabama. It's called Merrill v. Milligan, which also concerns allegedly gerrymandered maps, but involves the Voting Rights Act and whether the Voting Rights Act can protect minority voters from having their votes deliberately diluted in congressional map drawing. Tell me how these are connected and the influence you think that they will have.
Well, the voting rights case is very important. As you say, the question is whether an Alabama court was right to say that Alabama had to draw a second majority-minority districts in which African Americans represented a majority, or would that violate the Voting Rights Act? And the stark claim before the court is that the Voting Rights Act, which was amended in 1982 to require the creation of majority-minority districts whenever minorities lacked an opportunity to elect representatives of their choice, whether that act is itself unconstitutional. Basically, whether the principle that the Constitution is colorblind prevented Congress from saying that there was an obligation to create voting districts for majorities. This is a position that Justice Clarence Thomas has taken for many years. Until just last June, there was no chance that it would have a majority, but it may now. And it would be a very dramatic final nail in the coffin of the Voting Rights Act, which the Supreme Court struck down in the Shelby County case and said that Section 5 did not allow the redressing of past discrimination. And now, in this case, it might strike down Section 2 as well, a case with huge implications.
Fatima, let's talk about affirmative action cases. There are 2 of them. They used to be combined. Now they've been split back into 2 separate cases. Tell us a bit about what these are and the effect of them.
Yeah, the reason they have been split is that Justice Ketanji Brown Jackson has recused herself from the Harvard case. So both Harvard's admissions policy and the University of North Carolina's admissions policies have been challenged by anti-affirmative action cases, arguing that their policies to consider race as one of many factors discriminate against both white and Asian American applicants. And even though there have been detailed trials that have found otherwise, there's a giant worry that the court is taking these cases and what it will do, that it will use it as another opportunity to overturn longstanding precedent that has said that race among many factors can be considered. And the irony in these cases is that some of the states where affirmative action has been banned, they have been trying to figure out how do we bring it back to ensure that there are diverse and fair learning spaces for people in higher education, understanding the deep value for their students and for their communities.
Jeff, let's talk about the discrimination case out of Colorado. It's very similar to the wedding cake case from a few years back. A web designer would like to refuse service to gay customers, and the question is, can they do that? How is this case different from the Colorado wedding cake case, and why is the court hearing this case now?
You're absolutely right, Ali. It is very similar. And the only difference is in the wedding case, the court ducked the question of whether it was a violation of the First Amendment free speech rights and free exercise of religion rights to refuse to bake a cake or perform a service. And here they're probably going to confront it squarely. This is a website designer who says, I'll make websites for gay couples. I just won't allow them to advertise gay weddings on my site. And the question is, can she do that? And now the court could rule a little more narrowly and say that artists have an ability not to be compelled to speak messages that they don't like, but it could rule broadly and strike a hole through the heart of anti-discrimination laws and say that anyone who doesn't want to perform services for gay couples can do that if they have a legitimate religious belief. This is at the heart of the conflict between anti-discrimination laws and free exercise of religion that the court's been confronting in a whole bunch of cases this year. And for that reason, it could be hugely significant.
So you're standing, in fact, Jeff, the image behind you is the First Amendment at the National Constitution Center, and that, of course, protects the freedom of speech. But, Fatima, the issue is that when the Supreme Court heard the wedding cake case in 2018, it was, I'm not going out on a limb here, less conservative than it is today. So maybe the court won't skirt around that issue the way Jeff just described, and will say, yeah, totally okay to discriminate against someone if they're gay. You can't enter my business. I cannot provide a service to you because of the basis of my beliefs. What do you think?
You know, we're preparing ourselves for that sort of upside down ruling, which would be in such sharp contrast from where people in this country are. People in this country don't want to tolerate discrimination. And at the heart of it is we're talking about if someone is holding themselves out for a public service in the community, and that includes selling website design for a wedding. They're basically wanting to say, everyone but you. We want to be able to discriminate against people based on their sexual orientation. That is so not where this country is today. So it's shocking that that is where we might be with a court that could have a ruling that would further and encourage discrimination.
Jeff, is it possible that the decision to overturn Roe was a one-off in terms of sort of the shock value and how bad it was, or is this the first step in a long march that people are going to be very worried about?
It's the first step in a long march. There's no doubt, as the liberal dissenters have said, that the conservative majority is in a hurry, that it really is eager to overturn lots of precedents that it thinks are inconsistent with the text and history of the Constitution. And these cases involving race we've been talking about, the Affirmative Action case and the Voting Rights Act case, could indeed overturn key precedents that have upheld affirmative action for decades, and in that sense be just as consequential in the area of discrimination as Dobbs was in abortion. So it's going to be another blockbuster term, huge changes ahead, and we definitely should watch it very closely.
I feel like PayPaling you both some tuition money for all that I have learned. That was absolutely tremendous. Thanks to both of you for your expertise and your analysis. We all need it right now, and I'd like to do this again with you both. Jeffrey Rosen is the president and the CEO of the National Constitution Center. Fatima Goss-Graves is the president and the CEO of the National Women's Law Center.